This case really is a tragic relic of earlier times. HMAS Australia was a Navy warship built in the mid-1920s and still operating as Australia's flagship during the Second World War. Riley, Gordon and Elias were stokers looking after the ship's engines. It seems, though, that they were also homosexual and had been involved with one another at various times during their service. These days, that would hardly raise an eyebrow, but back then, homosexuality was both a criminal and a military offence. It seems likely that one evening in March 1942, Elias made a threat to expose the other two as homosexual. Had he done so, they would have been publicly shamed, thrown out of the Navy, and probably jailed. What happened next remains partly a mystery. It seems most likely that Stoker Gordon responded to the threat by attacking Riley, who screamed. By the time other crew members arrived, Riley had been stabbed 14 times, and Gordon and Elias were standing over him, covered in blood. Riley was rushed to the medical bay where he named Gordon as the attacker before dying from his wounds. Gordon and Elias were both charged with murder and tried by court-martial. They were sentenced to be hanged. They appealed all the way to the High Court, one of just 16 High Court cases where the death penalty was considered. The High Court upheld their conviction and their sentence, and they appealed to the King for clemency. Clemency is one of 3 traditional prerogative decisions which can be made by the Crown, which means either by the monarch or by the Governor-General or by a governor in a criminal matter. Clemency reduces the death penalty to life in prison. The other 2 prerogative decisions are mercy, which means that a convicted person's sentence is not imposed, and pardon, by which a person's conviction is removed altogether. The thing is that these prerogative decisions are quite simply the personal choice of the person making the decision. They look a lot like administrative and sometimes judicial decisions, but they are not. They're a special type of decision, a historical artefact of the days when kings and queens had supreme power. They can't be appealed or reviewed, and they remain as a rare safeguard for situations where the letter of the criminal law might nevertheless work an injustice.